Good afternoon. How's everybody doing? Great to be learning with you on a Friday, Yom Shishi. Let's light up the darkness. Who's in the house on a Friday? Yehudit in South Carolina, Paul in the Great Northwest, Stephen in New Hampshire, Sharon in New Jersey, Melissa in Great Neck, Lorraine in Texas, Gordo in Scotland, Bella in Florida, Guy in Ohio. Sal, I hope you're not winded from the rush home. I gotta tell you, it has been a hectic few days. I was in Dallas last night for a screening of Guns N' Moses special event. Flew in early this morning, rushed to synagogue because I especially wanted to daven with a minyan, to pray with a minyan today, because this is my grandmother's yahrzeit. My grandmother, Magda, her Hebrew name was Sarah Bat Shmuel. May the neshama have an aliyah, and I would like to dedicate our learning today to her memory. I was very, very close with her. Many of you have heard my story, how being present at her passing and seeing with my eyes her reunion with her husband, my grandfather, whom she lost in the Holocaust, and was waiting 53 years to be reunited with him. I'm not a person who sees things. I don't see visions, but I saw that, and it really redirected my life. It ended up connecting with Judaism, becoming curious, not only about the Torah, but the Talmud, and eventually stumbling into Daf Yomi, becoming the accidental Talmudist, and today teaching this class. All, I credit directly to my grandmother, Magda. And today is her yahrzeit. May the neshama have an aliyah. But between leading the services and blowing the shofar in synagogue today, I taped an appearance on the Michael Medved show. He really enjoyed Guns N' Moses. We'll be talking about it on his show today. And now with you. And then the movie opens 500 theaters across America on Sunday. Nina and I will be personally appearing here in LA at the show on Sunday night at AMC Universal. I think Monday night we're going to be at the Regal in Sherman Oaks. Rabbi Nolan Leibovitz will be moderating that talk. Then the last day on September 11th, 9/11, up in Santa Clarita, where we shot the movie. We'll be there for a Q&A. So very exciting times for us. I'm definitely rushing around, and I'm so excited for Shabbos. Thank God for Shabbos, that no matter how busy it gets, when it was production, when it was post-production, now promoting the release, Friday night, bada bing. Thank you, God. Thank you for the gift of Shabbos. Where was I? Renee in Indiana, Shendor in the Bronx, Lucy in Minnesota, Nancy in North Carolina, John Strong says hello. Welcome, John. Sharon says they could not have been happy last night in Dallas. Spoken as a Philadelphia Eagles fan. You know what? I've been so out of touch with sports. I love football. I mean, I'm a New York Giants fan, so we've had our good years, and it's been a while, but I've been completely out of touch with sports. Yehudit, yes, Guns N' Moses is coming to Florence, South Carolina on Sunday, and I'm going to see it again 5 minutes from my house. Fantastic. Thank you, everybody, for your support. And really, today's a great day to text and email a bunch of friends and wherever they live around the country. Go see Guns N' Moses. Support this film. The more we succeed in theaters, the better we'll do when it comes to streaming in about a month. And we need to succeed so that Nina and I can have the opportunity to make another movie. And our next movie that we have planned is a biblical thriller that, you guys will love so much. But we're not going to get that opportunity if this movie doesn't succeed. So the movie's got to do well. Over there on the YouTube side, Aoife in Florida, and Enoch. Well, hello, Enoch. Welcome to the show. Okay. So no double dafs, at least here in chapter 1 of Horayos. These are long and intense pages. So our daf today is page 3. Page 3 here in Tractate Horayos, the 28th volume of the Talmud. Continuing our discussion of Mishna number 1 or number 2? Still Mishna 1, right? Yeah, still Mishna number 1 here in chapter 1. Okay, this is all about what happens when the court, and specifically the Sanhedrin, makes a mistake and says that something is forbidden is permitted, and then people, for example, people rely on that ruling and basically commit a sin, something that was not permitted to do, but they relied on a ruling of the court. And as we see, there's very much conflicting views among the sages. Seems like the law is, at least according to the Mishnah, that the people, the individuals who rely on the ruling of the court are exempt from bringing a sin offering, and the members of the court will become liable to bring the special offering of a court that made an erroneous ruling that people relied on if a majority of the congregation relies on that ruling. Otherwise, that wouldn't apply. And let's keep in mind that when we say liable or exempt to bring a sin offering, it's not like the word liable is like, you don't want to be liable. You don't want to be liable. That's going to cost you a lot of money, right? But in fact, when we're talking about bringing offerings in the temple, bringing a sin offering is an opportunity to square your accounts and to have a very spiritual, incredible experience, possibly, only when the Holy Temple is standing in Jerusalem, and tragically it hasn't in 2,000 years, but may it stand again soon with the coming of Mashiach. Okay, we picked this up near the top of page 3a. Up to this point, the Gemara explained the Mishnah in accordance with the opinion of Rabbi Yehuda and contrary to the opinion of the rabbis who disagree with him, right? And seemingly, contradicting what we thought we read in the Mishnah, where the individual is exempt, but then it turns out, well, no, actually the individual, at least according to one of these opinions, he also has to bring the sin offering in addition to the court bringing the offering, or other views saying, well, sometimes the court member who, says, no, you guys are wrong to the rest of the court, but then he does it anyway, he's going to be liable. So there's all kinds of nuances in this, and let's see if we can track it closely. Okay, so up to this point, the Gemara explained the Mishnah in accordance with the opinion of Rabbi Yehuda, and that was contrary to the opinion of the rabbis who disagree with Rabbi Yehuda. And Rav Nachman says that Shmuel says, the Mishnah is the statement of Rabbi Meir, but the rabbis say an individual who performed a transgression on the basis of the ruling of the court is liable, right? He is liable. He's not exempt. Now, why would you be liable to bring a sin offering? Now, remember, the concept of a sin offering isn't that you did an intentional sin and you regret it and you want to atone for it. Atonement is possible. You can always make an atonement. But bringing a sin offering, that's for an unwitting transgression of a prohibition in the Torah. Unwitting means you didn't do it on purpose. Maybe you were negligent. Maybe you should have known better. It wasn't circumstances beyond your control, but you didn't know you were committing a sin. Now, if you're relying on a ruling of the court, isn't that an unwitting transgression? You thought it was permitted. The experts, right? The court told you could do it, and you relied on that. Sounds like an unwitting transgression. And that's why the view is that the person who relies on the court ruling does bring the sin offering, is liable to bring it. And the Gemara asks, what is the opinion of Rabbi Meir and what is the opinion of the rabbis to which Shmuel referred? It is as it is taught in a Baraisa. If the court issued a ruling and the judges performed a transgression on the basis of that ruling, Rabbi Meir deems them exempt and the rabbis deem them liable. Now we're not talking about the congregation, the people of the nation who rely on the ruling of the court. Now we're talking about the judges themselves. So the Gemara asks, who performed the transgression? If we say it is the members of the court who performed the transgression, Well, then what is the reasoning of the rabbis who deem him liable? But isn't it taught in a baraisa? One might have thought that if the court issued a ruling and the members of the court performed the transgression, one might have thought that they would be liable to bring a bull for an unwitting communal sin. Not the sin offering of an individual who relied on that ruling, but the court, right? The special sin offering for issuing the ruling. Well, isn't that for issuing the ruling on which the majority of the court relies? Why are we now talking about the judges themselves relying on that ruling and then bringing what? Their own version of the communal offering? Right? We're not sure what's going on here. Let's keep reading. The verse states, with regard to that bull, right? The bull for the communal reliance on the erroneous ruling, and the matter is hidden from the eyes of the congregation, and they perform. It's hidden from the eyes of the congregation because they relied on the erroneous ruling of the court. Sounds like the ones performing the transgression are the congregation, not the judges, from which it is derived that the action is dependent on the congregation, and the ruling is dependent on the court. When are we bringing the bull for the erroneous ruling? When the court issues an erroneous ruling and the congregation relies on it. Irrelevant whether the members of the court relied on it. So rather, the case in the baraisa where the court issued a ruling and the majority of the congregation performed the transgression on the basis of that ruling is what we're talking about. So if so, what is the reasoning of Rabbi Meir, who deems them exempt? Rather, is it not referring to a case where the court issued a ruling and a minority of the congregation performed the transgression on the basis of that ruling, which would not trigger the special bull for the erroneous ruling that the majority of the congregation relied on, and therefore presumably the minority that relied on it, unwitting transgression, and they should bring a sin offering, individual sin offerings, or not, because we already have a split view on that. And it is with regard to this matter that the Tanaim disagree. One sage, Rabbi Meir, holds an individual who performed a transgression on the basis of the ruling of the court is exempt. That's our Mishnah. And one sage, meaning two sages disagreeing with each other, but actually it's Rabbi Meir versus the majority. And the other sage, meaning the rabbis, holds an individual who performed the transgression on the basis of a ruling of the court is liable for a sin offering, because it really was at heart an unwitting violation of a prohibition. So the Mishnah, which states that an individual who performs a transgression on the basis of a ruling of the court is exempt, this is in accordance with the opinion of Rabbi Meir. So Rav Papa said, there is no proof that the dispute between Rabbi Meir and the rabbis relates to this Mishnah at all. Actually, they were talking about something else. Perhaps everyone agrees that an individual who performed a transgression on the basis of the ruling of the court is exempt, per our Mishnah. But what these Tanaim disagree with is with regard to whether the members of the court combine with the members of the congregation to complete a majority of the congregation. When do the members of the court bring the bull as a communal offering because the majority of the congregation relied on the erroneous ruling? When a majority of the congregation do. What if it's a minority of the congregation? What if we know that there's exactly 1 million people in Israel and 499,999 committed this transgression in reliance on the erroneous ruling of the court? Minority. So they don't bring that special bull offering. But what if members of the court relied on that ruling and brought the number of Jews who committed that transgression from 499,999 to 500,001? And now they're a majority. Can members of the court help make up the majority? That's the question. What they disagree with is regard to whether members of the court combine with the members of the congregation to complete a majority of the congregation. The members of the congregation who sin constitute less than a majority. When the judges of the court who sinned are added to that minority, the total of people who sinned constitute a majority. So, can we count the members of the court in the congregation to make the majority. They're disagreeing on that. One sage, the rabbis, holds the members of the court combine with the members of the congregation to complete a majority of the congregation. And the other sage in this dispute, Rabbi Meir, holds that members of the court do not combine with the members of the congregation to complete a majority of the congregation. Therefore, those who sinned on the basis of the ruling of the court constitute less than a majority, and the court is therefore exempt from liability to bring that special offering. The Mishnah is not only in accordance with the opinion of Rabbi Meir, as in the case of the Mishnah, but even the rabbis agree according to this. And if you wish, say instead that the dispute between Rabbi Meir and the rabbis is in a case where the court issued a ruling and a majority of the congregation performed a transgression on the basis of that ruling, and everyone agrees that the court is liable to bring a bull as an offering for an unwitting communal sin. Communal, because a majority of the congregation performed it. Rabbi Meir, in this situation, deems the members of the congregation exempt from bringing an offering. Now that the communal bull offering is being brought, because a majority of the congregation committed this sin in reliance on the erroneous ruling of the court, because the communal bull offering is being brought, the individuals who relied on that ruling don't have to bring an individual sin offering for that unwitting transgression. Which, if you think about it for a second, good policy, right? If it turns out that millions of people have committed an unwitting sin and then they all have to bring individual offerings, so the temple's going to be crowded. You're going to have a lot of business there, maybe more than it can handle. Rather, we have the special offering to make an atonement for the court and for the nation. Rabbi Meir deems the members of the congregation exempt from bringing an offering in that case. And who are the rabbis who deem them liable to bring an offering? The special bull offering is being brought to atone for the mistake of the court, and all the people who relied on it and committed an unwitting transgression do still owe a sin offering. And who says that? It is Rabbi Shimon, who said the congregation brings an offering and the court brings an offering. Or, if you wish, say instead that the dispute between Rabbi Meir and the rabbis is in the case of a tribe that performed a transgression on the basis of the ruling of its tribal court. This is like when there were tribal regions of Israel, almost like states in, a united states. So these were the tribal areas, right? You still have Yehuda and Shomron, which are parts of Israel. We'll leave it at that. And there was Benjamin and Dan, right? And Reuven. And the tribes had their portions by tribe in the nation of Israel. And there were tribal courts. Here we're going to talk about, can you constitute a majority of tribes, even if it's not a majority of population? Let's keep reading. Say instead that Rabbi Meir and the rabbis dispute in the case of a tribe that performed a transgression on the basis of the ruling of its tribal court. So Rabbi Meir holds that there is no liability to bring a bull as an offering for an unwitting communal sin for a ruling issued by a tribal court. Because when we're talking about the congregation, in this situation, we're talking about the nation, not a subunit of the nation like one of the tribes. Therefore, he deems the court exempt from bringing an offering. And who are the rabbis who deem the tribal court liable to bring such an offering? It is Rabbi Yehuda, as it is taught in a Baraisa in the case of a tribe that performed the transgression on the basis of the ruling of its tribal court. The tribe is liable because Rabbi Yehuda would say that a tribe is a unit unto itself, and this law will apply to a congregation that constituted of a tribe. And if you wish, say instead, a totally different analysis, say instead that the dispute between Rabbi Meir and the rabbis is in a case where 6 of the 12 tribes sinned, and although they do not constitute a majority of the number of the tribes in terms of population, they do constitute a majority of the congregation. Or 7 tribes sinned, and even though the terms, in terms of population, they are not a majority of the congregation, they would constitute a majority of the tribes. So now we're again looking at the congregation, means the whole nation that live in the land of Israel. And how do we achieve a majority of that congregation? Either through a numerical majority of the population, or through a majority of the tribes. And if so, either kind of majority of the individuals or of the tribes relied on the erroneous ruling, then we trigger that special bull offering according to this view. And whose opinion is expressed in the Baraisa as the opinion of the rabbis under that analysis? It is the opinion of Rabbi Shimon ben Elazar. And this is, as it is taught in the Baraisa, Rabbi Shimon ben Elazar says in the name of Rabbi Meir, if 6 tribes sinned, and in terms of population they're a majority of the congregation, or 7 tribes sinned, even though in terms of population they are not a majority of the congregation, they are liable. In other words, you can make up a majority either way, through majority of individuals or majority of tribes. All these alternative understandings of the dispute between Rabbi Meir and the rabbis lead to the conclusion that there is no proof for the statement of Rav Nachman in the name of Shmuel that the Mishnah is in accordance with the opinion of Rabbi Meir, because Rabbi Meir might have been talking about a different issue. New subject. Rav Asi says, and with regard to the definition of the majority that establishes liability for performance of a transgression on the basis of the ruling of a court, follow the majority of the residents of Eretz Yisrael. Not the majority of all Jews in the world, but the majority of residents in the land of Israel. As it is stated, quote, and Solomon held the feast at that time, and all Israel was with him, a great congregation, from the entrance of Hamath until the brook of Egypt, before the Lord our God, 7 days and 7 days, 14 days, 1 Kings 8:65. I think that's the inauguration of the temple. And the Gemara clarifies the words of this verse. Since it is written, and all Israel was with him, why do I need to add a great congregation from the entrance of Hamath until the brook of Egypt? Conclude from it, it is these residents of Eretz Yisrael who are characterized as a congregation, but those who reside outside Eretz Yisrael are not characterized as a congregation. Next subject. The Gemara continues defining the majority that establishes liability for that special sin offering of relying on an erroneous court ruling. It is obvious that the case of when those who performed the transgression on the basis of the ruling of the court were numerous, i.e. they constituted a majority, and their percentage is diminished. For example, if some sinners died and they now constitute a minority of the congregation, that is a dispute between Rabbi Shimon and the rabbis who disagree in a Mishnah on page 10b with regard to an anointed high priest or a king who performed an unwitting transgression before assuming his position. Right, so what they're going to talk about now is, right, because we're getting into the nuances of, did a majority of the congregation rely on an erroneous ruling of the court, which would trigger that special offering? And now what they're going to say is, well, what if when they did it, they were not, they were a majority, right? When they did it, they were a majority of the congregation. But when they became aware that the ruling was erroneous, a day later, a month later, a year later, who knows? So when they became aware that the ruling was in error, people had died. And now the total number of those who relied on the erroneous rulings is no longer a majority of the congregation. Now it's a minority. So we're going to compare when they committed the sin to when they became aware that the ruling was in error, to question, if we don't have both, the majority at the time of the sin and the majority at the time of the awareness, if we don't have it at both times, do we trigger that special offering or not? And we're going to compare the law of if a high priest, a Kohen Gadol, or a king committed a sin that would produce a different result if a king commits that sin, or if a regular Yisrael commits that sin, or if a high priest committed that sin, or if a regular Jew committed that sin, it would have a different offering, a different result, a different consequence because of the sanctity and the importance of the office. Well, what if they committed the sin when they were a regular person, then they became king, and only then they found out that they committed a sin. So do we have the consequence of when, based on when they committed it or when they found out about it? You can see why it's comparable. So the rabbis hold, since they were laymen when they sinned, in this Mishna that we're going to have on page 10 about a king or a high priest committing a sin before they became high priest or king, since they were laymen when they sinned, they are liable to bring the offering of a layman. Rabbi Shimon holds, if they became aware of their transgression while still laymen, they bring the offering of a layman. But if they only became aware of their transgression after they assumed their position, then they are exempt from bringing such an offering. Accordingly, in the case of a majority whose number diminished, the rabbis hold that since it was a majority that sinned, they bring an offering. The court brings that special offering. And Rabbi Shimon holds that it depends on their status when they became aware that they had unwittingly sinned. If those who performed the transgression on the basis of the ruling of the court were few, meaning they were a minority, and their percentage increased, for example, if some non-sinners died and the sinners now constitute a majority of the congregation, then what is the law? Do Rabbi Shimon and the rabbis disagree with regard to this matter as well? That would mean that Rabbi Shimon, who follows the status at the time of awareness, deems the court liable, and the rabbis who follow the status at the time of the transgression deem the court exempt. Or do they not disagree? What is the conclusion? And can you understand that this case is contingent on the dispute between Rabbi Shimon and the rabbis about a sin committed by a person before he became high priest or before he became king? Does that really apply? Does that outcome, can it be applied here? In a case where we're asking there was a majority that committed the sin based on the erroneous ruling, but by the time they learned there was an erroneous ruling, they're no longer the majority? Is it analogous? And can you understand that this case is contingent on the dispute between Rabbi Shimon and the rabbis? Say that you heard that Rabbi Shimon follows the status at the time of awareness as well, i.e. in a case where both the awareness and the transgression were in a period of liability, either liability as a layman or liability as a king or an anointed high priest, so the sinner is liable to bring an offering. But in a case where the awareness was during a period of liability, but the transgression was not, did you hear Rabbi Shimon say the court is liable? And the Gemara explains, as if it is so that Rabbi Shimon holds that the period of awareness is the sole determining factor when they found out that they committed a sin, let the high priest and the king bring an offering according to their present status. If they became aware of the transgression after assuming their positions, let them bring the offering appropriate for a high priest or a king. Why then does Rabbi Shimon not say that even though they committed a sin, which as a layman, and if they learned that they committed that unwitting sin while they were still a layman, they would bring the offering of a layman. But in our case, they committed the sin while they were a layman, then they became king, and then they learned that they committed that sin. Okay, so then when a king commits that sin, he's not exempt. He just brings a different offering than a layman brings. So why did Rabbi Shimon say he's exempt? Rather, apparently, Rabbi Shimon requires that both the transgression and the awareness take place in a period of liability. And if they were split, then the person loses the opportunity to bring a sin offering because the correct sin offering no longer applies to him, and he can't bring the offering of a layman because he's no longer a layman, and he can't bring the offering of a king because when he committed the sin, he wasn't a king. That's why, according to Rabbi Shimon, he's exempt. But can we apply that analysis to this case of the majority that became a minority? Rather, we have no resolution to this question, and we don't know what Rabbi Shimon would hold. New subject. A dilemma was raised before the sages if the court issued a ruling that forbidden fat is permitted, right? That's a type of example that we keep bringing up, that a part of the animal that's not kosher for eating, and the court made a mistake and said it's permitted, right? And so people relied on the erroneous court ruling to eat that which is prohibited. They violated a negative commandment, a prohibition, based on the permit or the permission of the erroneous court. So if the court issued a ruling that forbidden fat is permitted, and a minority of the congregation performed the transgression of eating forbidden fat, on the basis of the ruling, and the court then reversed their decision. Okay, they said, oh, we were wrong. So now we have a case where minority sinned, minority of the congregation, and then the court realized it was wrong and said so. So in that situation, they don't bring the bull because a majority of the people didn't rely on it. And presumably the individuals who relied on the erroneous ruling, according to our Mishna, don't bring individual sin offerings. And according to, I guess, Rabbi Yehuda, they do, or at least the opposing view. Okay. But then something odd happened. What happened was, this is such a hypothetical, right? It's just really to get our minds around what's being said here. So a minority of the congregation relied on the erroneous ruling that what is actually a forbidden fat is permitted. Then the court reversed their decision, and then the court reversed its decision again and issued the same ruling as in the beginning, that what is actually forbidden is permitted. They went back to their erroneous ruling. And then a different minority of the congregation performed the transgression. Then what is the law? And so the Gemara explains, is it that since there are two disparate experiences of awareness, the first minority does not combine with the second minority, even though the two minorities together would constitute a majority? Or perhaps since both this transgression and that transgression are the same, eating the forbidden fat, based on this ruling of the court that it's permitted, even though it was two separate instances of erroneous rulings, do we combine those minorities, since they relied on the same ruling but issued at different times, to say that a majority of the congregation committed this unwitting sin based on the erroneous ruling of the court, and therefore we trigger the special offering, etc.? Or do we not combine the minorities, since each minority relied on a separate ruling? And if you would say, in that case, that since both this transgression and that transgression are the same, eating forbidden fat, therefore the first minority combines with the second minority, then we raise a new dilemma. In a case where a minority performed the transgression on the basis of the first ruling of the court and ate forbidden fat that is upon the maw, and the minority performed the transgression on the basis of the second ruling of the court and ate forbidden fat that is upon the small intestine, then what is the law? In other words, there were two different rulings and two different minorities that relied on it. They were very similar rulings. Both erroneous rulings said that a fat that is actually forbidden is permitted and people relied on it. But it wasn't exactly the same fat. There's the fat from one part of the cow and a fat from a different part of the cow. So do we say that, well, in the end, both minorities ate a forbidden fat based on an erroneous ruling of the court, and therefore we do combine them to say a majority relied on an erroneous ruling, and we trigger the special offering, right? The Gemara elaborates here, certainly, since these transgressions come from two different verses in the Torah, the first minority does not combine with the second minority. Or, perhaps, you say, since both this transgression and that transgression are the same, eating forbidden fat, even if from a slightly different part of the animal, so the first minority does combine with the second minority, and the two minorities together create a majority and trigger the special offering. If you would say that, because it is the same, it is the name of forbidden fat that they both have in common, and the first minority does combine with the second minority, then we raise a third dilemma. In a case where a minority performed the transgression on the basis of the first ruling of the court and ate forbidden fat, and a minority performed the transgression on the basis of the second ruling of the court and ate forbidden blood, then what is the law? Now, what they did is both of them ate something in reliance on an erroneous ruling. But the first group ate a forbidden fat. The second group ate forbidden blood, right? Kosher food does not contain the blood. When there's a kosher animal slaughtered, all the blood is drained out. The Torah says in several places, you shall not eat the blood of an animal because the blood is the life. But let's say the court made some kind of a mistake and permitted it. Would we combine these two minorities? Here, certainly, there are two distinct prohibitions. And since the nature of their prohibition is not identical, the first minority does not combine with the second minority. Or perhaps, since their offerings are identical, if you commit this sin unwittingly, what is the sin offering that is triggered? It's the same whether an unwitting transgression of don't eat forbidden fats or an unwitting transgression of don't eat the blood. If you did that sin unwittingly, the offering that you would bring to atone for it when the temple is standing is the same offering. And since the offerings are identical, as one is liable to bring a sin offering for unwitting violation of either of these prohibitions, perhaps the first minority does combine with the second minority. And if you would say in that case, yes, since their offerings are identical, the first minority combines with the second minority, well, then we raise yet another dilemma. In a case where a minority performed a transgression on the basis of the first ruling of the court and ate forbidden fat, and a minority performed the transgression on the basis of the second ruling of the court and engaged in idolatry, then what is the law? Here, certainly, neither are the prohibition identical, nor are their atonement offerings identical, because an individual who unwittingly engages in idolatry may bring only a female goat for atonement. Therefore, the first minority does not combine with the second minority. Or perhaps, since for both this transgression and that transgression, if one was to do it intentionally, he would receive excision from the world to come, charis. Therefore, the first minority does combine with the second minority. Is that enough of a commonality? That these sins are totally different. They're different prohibitions, different atonements, different punishments, but not different punishment. Same punishment. You know, they're totally different sins that are atoned for with different offerings. The punishment for doing it intentionally would be the same. Is that enough to combine those minorities and say there's a majority that relied on different rulings, but of the same court? So could we say that they combine? Teku, these dilemmas stand unresolved. New subject. A dilemma was raised before the sages. If the court issued a ruling that forbidden fat is permitted, and a minority of the congregation performed the transgression of eating forbidden fat on the basis of that ruling, and the members of that court died, and another court stood in their place, and again issued the same ruling that forbidden fat is permitted, and a different minority performed the transgression of eating forbidden fat on the basis of that ruling, then what is the law? Right? Now it's the same transgression, but two different courts created two different minorities. Can we combine those minorities and say that a majority relied on an erroneous ruling and trigger that special offering? According to the opinion of the one who said that only the court brings in the offering, there is no dilemma, as those judges who issued the original ruling on the basis of which the minority performed the transgression are no longer alive. Rather, when should you raise this dilemma? Raise it according to the opinion of the one who said that the congregation brings the offering. Then what is the law? So the Gemara elaborates, the congregation exists, as together the two minorities constitute a majority of the congregation who performed the transgression. Or, perhaps, for liability to bring the offering, we require the awareness of the same court that issued the ruling, and that court no longer exists. What's the answer? Teku. The Gemara concludes that this dilemma shall stand unresolved. We are on page 3b. Rabbi Yonasan says, even in the case of 100 judges who convened to issue a ruling and made a mistake, they are not liable to bring an offering unless they all issue that ruling, as it is stated with regard to liability to bring the offering, and if the entire assembly of Israel shall act unwittingly. Now, when we say the entire assembly of Israel, we've said that that really means a majority of the congregation follows the erroneous ruling. The erroneous ruling could come out as a result of a divided court and the majority make the mistake. But according to Rabbi Yonasan, no. For this special offering to be triggered, not only is that the majority of the congregation has to rely on it and commit the sin unwittingly, relying on the erroneous ruling, but the ruling itself has to emerge unanimously from the court, even if it's 100 judges. Well, 100 judges are going to have a unanimous ruling on a matter of law where it's nuanced law that could produce an error? Seems pretty unlikely. Is this a requirement that's going to mean that in practical terms, this erroneous ruling will never happen? Let's keep reading. Unless they all issue that ruling, as it is stated with regard to liability to bring the offering, and if the entire assembly of Israel shall act unwittingly, from Leviticus 4:13. Now, from the term entire, it is derived that the judges are not liable until they all act unwittingly, and the ruling must disseminate and be adopted throughout the entire assembly of Israel. And when we say the assembly of Israel, we're not talking about the population and the congregation of Israel. We're talking about the Sanhedrin, the leadership. Rav Huna, the son of Rav Oshaya, said, so too it is reasonable to conclude this, as throughout the entire Torah, we maintain the principle. The legal status of the majority of an entity is considered like all of that entity. And here, the entire assembly is written. Since it is so, a majority does not suffice, right? If we had said assembly, we would have known that it meant majority. But since the word entire is there, it means, according to this derivation, that we need unanimity among the whole Sanhedrin, which had a minimum number of 71. Since it is so, a majority does not suffice. Even if they are 100 judges, they become liable for the special offering only if the erroneous ruling was unanimous. We learned in the Mishna, if the court issued that ruling and one of the judges knew that they erred, they'd made a mistake, despite the fact that the majority ruled against his opinion, or if he was a student and he was qualified to issue halakhic rulings, and that judge or student proceeded and performed the transgression on the basis of the court's ruling, then whether the judges performed the transgression and he performed it with them, or whether the judges performed the transgression, he performed it after them, or whether the judges did not perform the transgression and he performed it alone, in all these cases, the judge or the student is liable to bring an offering, and this is due to the fact that he did not associate his action with the ruling of the court, which I find so confusing, right? Because what they said is the court made a mistake, right? So if individuals of the people follow the court's mistake, according to our Mishnah, they're exempt from being a sin offering because they relied on the court that they trust to issue correct rulings. Here's a member of that court. He said, you guys got it wrong. He's right. They got it wrong. And he told them so. But then he says, okay, well, they said it's the ruling, so now it's the ruling. So he goes and relies on them. But they're saying that even though he is doing it because they said so, since he knew that it was wrong, he is not exempt. Like a regular member of the public, he would be liable to bring the sin offering. What I don't understand is why you would characterize that as he did not associate his action with the ruling of the court. Why else did he do it? He himself knows it's wrong. He's only doing it because the court said so. So I'm a little confused there. The Gemara notes that one may infer, it is this judge or student who is liable, but another who acts on the basis of the ruling of the court is exempt, right? A regular person. But why would he be exempt? The ruling is not completed if it is not unanimous. Here we don't have a unanimous ruling. We know that somebody said, hey, the rest of you got it wrong. What are we dealing with here? We are dealing with a case where the one who dissented among them bowed his head and indicated his agreement with the remaining judges. He knew they were wrong, but he said, I will not, violate the unanimity of the court. I will, since all of you are saying I'm wrong, you're right and I'm wrong, it must be I'm wrong. And he bows his head and goes along with it. That's how you could have a unanimous ruling, even though he knows better. Now the Gemara suggests, come in here, proof from a Mishna on page 4b. If the court issued a ruling and one of the judges knew that they erred, and he said to them, you are mistaken, they are exempt. They are exempt. But he told them and they issued the ruling anyway. Why are they exempt? The reason that they are exempt is that the judge said to them, you are mistaken. But if he was silent, they are liable, and the ruling is complete. And why, according to Rabbi Yonasan, would they be liable? But isn't it so that not all of them issued the same ruling? And the sages say in response, so too here is a case where the dissenting judge bowed his head. So Rav Misharshia raises an objection to the state. Silence, no good in that situation. He should not have bowed his head. And that's why now it becomes on his head, the liability, and not theirs. Rav Misharshia raises an objection to the statement of Rabbi Yonasan from a Baraisa. Our sages relied on the statement of Rabbi Shimon ben Gamliel and on the statement of Rabbi Elazar, son of Rabbi Tzadok, who would say, one does not issue a decree upon the congregation unless the majority of the congregation is able to withstand it. Right? We've seen this principle before. The sages didn't issue decrees to protect the congregation from coming to violate prohibitions in the Torah if the congregation was not going to follow the decrees of the sages. So Rav Ada bar Abba said, what is the verse from which this principle is derived? It is derived from the verse, with the curse you are cursed, yet you rob me, the entire nation, from Malachi 3:9. So the verse is referring to the oath taken by the entire people to observe the laws of tithes. And they violated those laws. But here it is written, the entire nation. And yet, Rabbi Shimon ben Gamliel and Rabbi Elazar, the son of Rabbi Tzadok, relied on this verse to derive the legal status of the majority of an entity, to derive that the legal status of the majority of an entity is like that of the entire entity. And therefore, if a majority of the congregation can withstand the decree that the court can withstand the decree of the court, then the court may issue it. So the Gemara concludes the refutation of the opinion of Rabbi Yonasan is indeed a conclusive refutation. And the Gemara asks, well, rather, now that Rabbi Yonasan's opinion has been refuted, what is derived from the phrase, the entire assembly, that the merciful one states? Well, this is what it is saying. If there are all the judges present, and they issue that ruling based on the majority, it is a ruling. And if not, it is not a ruling. So you don't need all 100 to agree with it, but you need all 100 to be present when the ruling is issued. So the Gemara, so with regard to a court session, Rabbi Yehoshua says, when there are 10 judges who sit in judgment, the chain is placed around the neck of the person taken to his the chain that is placed around the neck of the person taken to his punishment is suspended around the neck of all of them. This is metaphorically means that they are all responsible for the decision, right? All the court members who issue, let's say, a death sentence, that's what they're talking about, a collar around the neck of the defendant, they're all responsible for it, even the ones who dissent. Because they're part of that court. And the Gemara asks, well, isn't this obvious? The Gemara answers, this teaches us that even a student before his teacher may not be silent in deference to his teacher, as he bears responsibility for an erroneous ruling. You can't just sit there and be quiet. If you know it's wrong, you must speak up. And the Gemara relates Rav Huna, when he would go out to the court to sit in judgment, he would bring 10 Tanaim, i.e. people who recited Mishnayos and Baraisas in the study hall, to sit before him and serve as partners in judgment with him. And he said, I do this so that we will each receive a splinter from the beam, i.e. each of us will bear only a small part of the responsibility. Not just technically we'll have less blame, but we'll have a discussion, right? So we are more likely to arrive at the right outcome. And Rav Ashi, when they would bring a slaughtered animal before him to determine whether or not it was a treifa, would bring 10 slaughterers from Mata Mechasia and sit them before him while rendering his decision. And he said, I do this so that we will each receive a splinter from the beam. And that concludes our discussion of Mishnah number 1 here in chapter 1 of Tractate Horayos. Mishnah 2. In a case where the judges of the court issued an erroneous ruling and they discovered that they erred and they reversed their decision, whether they brought their atonement offering for their erroneous ruling or whether they did not bring their atonement offering, and an individual who was unaware of the new ruling proceeded and performed the transgression on the basis of their first ruling, so Rabbi Shimon deems him exempt from bringing an offering, and Rabbi Elazar says there is uncertainty there is uncertainty with regard to his status, and he is liable to bring a provisional guilt offering, which is the case of uncertainty for which one is liable to bring a provisional guilt offering. If one sat inside his house and performed the transgression, he is liable to bring the provisional guilt offering, as he could have learned of the change of the court's ruling. But if he went to a country overseas and was relying on the initial ruling, he is exempt because he never heard that the court reversed itself. Right? So we're seeing that, okay, court issued an erroneous ruling, people relied on it, then they reversed it, they brought the communal offering, and then somebody relied on the original ruling. Right? Is he going to be exempt like the people who relied on the erroneous ruling before it was reversed? Or are we going to say, no, now it's been reversed. So if he relied on that original ruling, he made a mistake. He shouldn't have done that. He should have known better. Well, if he was away overseas, how could he have known better? Therefore, he's exempt. If he's in the country, but somehow wasn't paying attention to the news, then we're not sure, or he's not sure, should he have heard about it, should he not? There's uncertainty, and that's why he brings a special offering, the provisional guilt offering. That's brought when you're not sure whether you committed an unwitting sin or not. Rabbi Akiva said, I concede in that case of one who went overseas that he is closer to exemption than he is to liability. And as I said to him, in what way is this person who went overseas different from the one who sits in his house? And Rabbi Akiva said to him, well, the difference is that with regard to the one who sits in his house, it would have been possible for him to hear the court's reversal. But with regard to that person who went overseas, it would not have been possible for him to hear the court's reversal. So the Mishna explains for which type of unwitting transgression, based on the ruling of the court, there is liability to bring an offering. In a case where the judges of the court issued an erroneous ruling to abolish the entire essence of a mitzvah, not only a detail thereof. For example, right, so here we're going to talk about the difference between the court made a mistake in some kind of nuanced little decree, interpretation of the law. They ended up getting it wrong, but you can understand how they made that mistake, versus judges who issued a ruling that is 100% contrary to what it plainly says in the Torah. How could they make such a mistake? Unimaginable, but if they did, is that going to produce a different outcome to a more understandable case where they got some kind of a nuance wrong? In a case where the judges of the court issued an erroneous ruling to abolish the entire essence of a mitzvah, not only a detail thereof. For example, they said, there is no prohibition against engaging in intercourse with a menstruating woman written in the Torah. That's patently false. Or, there is no prohibition against performing prohibited labor on Shabbos, written in the Torah. Obviously false. Or, there is no prohibition against engaging in idolatry, written in the Torah. What could be falser? These judges are exempt, right? Because it's not like they made some kind of, questionable deliberation and arrived at the wrong answer. Something crazy went askew here. And when it's that crazily off, then the bull offering for communal error wouldn't even apply. As this error is based on ignorance, not on an erroneous ruling of judges. If the judges issued a ruling to nullify part of a mitzvah and sustain part of that mitzvah, then we would trigger this special offering and they would be liable. How so? An example of this latter category where they would have liability is if the judges said, there is a prohibition against engaging in intercourse with a menstruating woman written in the Torah, but one who engages in intercourse with a woman who observes a clean day for a day she experiences a discharge is exempt. Right? That's wrong, but it's in the nuance area. Another example is if there is a prohibition there is a prohibition on performing prohibited labor on Shabbos written in the Torah. But one who carries out objects from the private domain to the public domain is exempt. Again, that is not exempt. It's prohibited to do that, but that's not written explicitly in the Torah, so the judges just got something wrong on a rabbinic level. Another example is if they said there is a prohibition against engaging in idolatry written in the Torah, but one who bows to the idol but does not sacrifice an offering to it is exempt. Again, that's false, but that's not explicitly written in the Torah, so it's about the rabbinic decree that they got it wrong. And that's why, and another example is, wait a minute. Right. And in all of these cases, these judges are liable, as it is stated, and the matter is hidden in Leviticus 4:13, from which it is derived that there is liability only if a matter, meaning a single detail, is hidden, but not if the entire essence of a mitzvah is hidden. Okay, that's Mishnah number 2. Now the Gemara. The Mishnah teaches that Rabbi Shimon deems exempt one who performed the transgression on the basis of the initial ruling of the court, even though the court reversed its ruling. And Rabbi Yehuda said that Rav said, what is the reason for the statement of Rabbi Shimon? The reason is, since it is with permission of the court that he performs the transgression, he is exempt. Some say that there is a different version of the statement cited by Rabbi Yehuda. Rabbi Yehuda said that Rav said, Rabbi Shimon would say, concerning any ruling that disseminated to the majority of the congregation, even if the court later reversed that decision, an individual who performs a transgression based on the first ruling is exempt, because a ruling is given only to distinguish between unwitting and intentional acts. One who performs an action on the basis of that ruling is unwitting, as he associated his action with the court. He relied on an erroneous ruling, and he is unaware that the court reversed its decision when he went and committed it again, or when he committed it even after the reversal, because he wasn't aware of the reversal. Now, the Gemara raised an objection from a Baraisa. For a bull brought for an unwitting communal sin, and for goats brought for the unwitting violation of the prohibition of idol worship, the temple treasury collects money from the congregation to pay for the offerings from the outset, i.e. a collection undertaken specifically for that offering. This is the statement of Rabbi Shimon. Rabbi Yehuda says the money for purchasing these offerings comes from the funds of the collection of the temple treasury chamber, just like the money for purchasing all the communal offerings. What's going to be the issue here? If they take up a special collection, say to the population, the court made a mistake, and everybody has to contribute a shekel to bring this communal offering so that we can all make an atonement, then more people are likely to hear that there was an erroneous ruling, and they won't come to rely on the error. But if they're going to use funds that are already in the temple treasury, we're not going to have, as much possibility of everyone hearing about the reversal. Since they collect money specifically for each of these communal sin offerings, the transgression is for him one that became known, as he presumably heard about the collection, and he should be liable because he's aware of the reversal in the court's ruling. The Gemara answers, if you wish, say that the reference in the Mishnah is to a case where they did collect money without specification. Therefore, he was unaware of the reversal of the court's ruling. They collected money, but they didn't announce that it was for a communal bull offering brought based on an error of the court. And if you wish, say instead that the reference in the Mishnah is to a case where the person was not in the city. Therefore, he was unaware of the collection of funds and unaware of the reversal when he relied on the original ruling, even though it had already been reversed. His sin was purely unwitting. And if you wish, say instead that Rav holds in accordance with the opinion of the other Tana who cited the dispute between Rabbi Shimon and Rabbi Yehuda, as it is taught in Baraisa, with the attribution of the opinions reversed. The temple treasury collects money from the congregation to pay for the offerings from the outset. This is the statement of Rabbi Yehuda. Rabbi Shimon says the money for purchasing these offerings comes from the funds of the collection of the temple treasury chamber that's already in the temple treasury. So according to Rabbi Shimon's opinion in this Baraisa, it is possible that the transgressor remained unaware that the court reversed its decision. Apropos this topic, it is taught in a Baraisa, if an individual performed the transgression on the basis of the original ruling of the court, after the court reversed its ruling, Rabbi Meir deems him liable to bring a sin offering, and Rabbi Shimon deems him exempt. Rabbi Lazar says there is uncertainty with regard to his status. In the name of Sumachos, the sages said his status is suspended and remains uncertain. Rabbi Yochanan said it is with regard to a provisional guilt offering that there is a practical difference between the opinion of Rabbi Lazar and the opinion of Sumachos. According to Rabbi Elazar, he is liable to bring a provisional guilt offering, whereas according to Sumachos, the question of his liability is suspended and he does not bring a provisional guilt offering. Rabbi Zera says there is an analogy to illustrate the opinion of Rabbi Elazar. To what is this matter comparable? It is comparable to a person who ate a piece of fat with regard to which there is uncertainty whether it was forbidden fat and uncertainty whether it was permitted fat. And he thought he was eating permitted fat. Not an erroneous ruling of the court, but a more typical case where he's not sure if what he ate was permitted or prohibited. He doesn't know and he can't know. That's why you would bring the offering for the cases of uncertainty. And he later became aware that there is uncertainty whether he unwittingly ate fat for which one is liable to receive charis if he ate it intentionally. As in this case, he is liable to bring a provisional guilt offering. In the case in the Baraisa too, when he later discovered that the court reversed its ruling, it is like one who is uncertain whether he associated his action with the court or associated his action with himself. Two different levels of uncertainty, right? Did he do it? And why did he do it? I'm almost done. I'm at the top of 4a. Just going to the next subject break. But questions or comments, please get them in now. And it is not necessary to state this according to the one who said that the congregation brings the offering, as in that case, the matter that the court reversed its ruling is publicized among the congregation. But even according to the one who said that the court brings the offering, where the matter is not publicized that the court reversed its ruling, if he had asked, they would have told him that the court reversed its ruling. Therefore, it could be said that he associated his action with himself and did not associate it with the court, and he is liable to bring a provisional guilt offering. And Rabbi Yosef bar Avin, and some say Rabbi Yosef bar Zavita, says there is an analogy to illustrate the opinion of Sumachos. To what is this matter comparable? It is comparable to a person who brings his atonement offering during twilight, which is a time when there is uncertainty whether it is day or night, and there is uncertainty whether the offering atoned for him while it is still day, and the atonement was effective, and there is uncertainty whether it atoned for him after nightfall, and the atonement was not effective. Somebody had to bring an atonement offering for some other sin. It had to be brought that day, but it was brought during twilight. Twilight is a period where we cannot know. We do not know, will not know, cannot know if it was during day or night. That's what twilight means. That's why we wouldn't bring offerings during that period if they needed to be brought during the day. But later he found out he brought it during twilight. So he cannot be sure whether that offering atoned for him or not. That's what we're talking about. The law is that he does not bring a provisional guilt offering for that situation, although typically one is liable to bring a provisional guilt offering in a case where there is uncertainty whether he performed the transgression for which he is liable to bring a sin offering. In this case, since the uncertainty relates to twilight and whether the offering that he brought was received or not, which is an uncertainty that can never be resolved because of the nature of twilight, it is not a typical uncertainty, and one is not liable to bring a provisional guilt offering for a situation that is atypical. And it is not necessary to state this according to the one who said that the court brings the offering, which is the case when the matter is not publicized that the court reversed its ruling. But it can be stated even according to the one who said that the congregation brings the offering, which is the case when the matter is publicized that the court reversed its ruling. And if he had asked, we would have said to him that the court reversed its ruling. And this is because here, in a case where there is uncertainty whether the offering atoned for him while it is still day, and there's uncertainty whether it atoned for him after nightfall, in which case it was not effective, if he asks, he would not find the person whom we could ask, because the uncertainty about twilight is a permanent uncertainty, and we can't extend the law from one area to the other. This is not easy stuff if you're confused. Me too. Probably you're confused because I'm confused. Okay, let's take some questions. Oh, reload my document. Here it comes. Sorry, I should have reloaded it when I said I'm taking questions or comments momentarily. It's almost reloaded. Sorry. Meanwhile, I bless us all that we should enter Shabbos hearing only good news and be refreshed and come out of Shabbos hearing only good news. Okay, 2 comments from Sharon. Regarding a sin committed before the layman became king, this is reminiscent of a person committing a crime as a juvenile, but is not tried and convicted until they are an adult. The punishment for that conviction is based on juvenile criminal justice. Makes sense, and since the court system is not fast, probably that's very often the case. And again, Sharon, are these two judgments about the fat from the same court? You probably said that before we got to where they said, well, what if it's two different courts? Do we combine them or not? Teku. That's what I've got for us today, and with God's help, we'll be together again tomorrow, Saturday, Motzi Shabbos. And, it's starting to get a little bit earlier each time. So as early as I can get to it tomorrow night, we'll have tomorrow night's daf. All the best.